For years, Americans walked into sheriff's offices with one question on their lips: can I protect myself? And for decades, the answer was, too often, no. Not because you were dangerous, not because you failed a background check, but because your reason for self-defense wasn't good enough for the state. New York, California, New Jersey. A web of laws, forms, and waiting rooms designed to delay freedom itself. But on one morning, the Supreme Court changed all of it. A 6-3 ruling tore through more than a century of excuses, red tape, and political fear. The justices didn't just issue an opinion. They reset the entire framework of how states handle your right to carry. And with a single sentence, they returned the balance of power to where it always belonged: the people. This wasn't just a legal decision. It was a constitutional shockwave, one that's now rewriting how America defines its freedom. Welcome to Firearms Rights Advisor, where we cut through the politics, strip away the spin, and bring you the real truth behind the battles that shape your rights. Let's break down what just happened and why this is only the beginning.
Chapter 1. The ruling that shook the nation. The case was New York State Rifle and Pistol Association versus Bruen, and it hit the courtroom like a thunderclap. For over 100 years, New York forced citizens to prove a proper cause before carrying a firearm in public. But proper cause didn't mean protecting your family or walking home safely after work. It meant proving you were in extraordinary danger, as if the right to self-defense had to be earned. Applicants were denied not for failing background checks, but for simply being ordinary citizens. Justice Clarence Thomas looked at that system and said, "The Second Amendment must be consistent with text, history, and tradition." With that one line, the court struck down a century of manipulated interpretation. The message was clear. You don't beg for a constitutional right. You don't justify it. You exercise it. This wasn't about one state. It was about setting a national precedent, one that puts the burden back on government, not the people.
Chapter 2. The Aftershock. States in Panic. The ruling landed, and within hours, the shockwaves hit. Across the country, blue state governors called emergency sessions. California, New Jersey, Hawaii, Maryland, all scrambling to rewrite laws that no longer stood on legal ground. Because this wasn't just a defeat, it was a declaration that their entire system of permission-based rights was unconstitutional. But instead of complying, they doubled down. New York passed its Concealed Carry Improvement Act, banning carry in almost every public space: parks, libraries, bars, subways, even Times Square. Critics called it a backdoor ban. Supporters called it public safety. But the truth? It was panic, pure and simple. Meanwhile, lawsuits exploded nationwide. Gun rights coalitions mobilized overnight, flooding courts with cases citing the new Bruen standard. What started as a single case became a legal chain reaction, a battle not between left and right, but between government control and individual freedom.
Chapter 3. Text, History, Tradition. The most important words you'll hear in this entire ruling: text, history, tradition. This is the new test the Supreme Court created, and it's a weapon of pure constitutional clarity. From now on, no law can survive unless it fits within the original meaning of the Second Amendment. That means no modern safety loopholes, no emergency excuses, no new definitions of old rights. Judges must now look back to 1791 when the Bill of Rights was born, or 1868 when the 14th Amendment applied it to the states. If there's no historical precedent for a gun restriction, it fails. This isn't theoretical. Federal courts have already used this test to strike down magazine bans in California, ammunition restrictions in New Jersey, carry limitations in Hawaii. This new standard doesn't bend with politics. It anchors the law to the Constitution itself. For decades, courts treated the Second Amendment like a second-class right. That era just ended.
Chapter 4. What it means for you. So what does this mean for the everyday gun owner? If you live in states like Texas, Tennessee, or Arizona, you're already ahead. Your rights were protected before this ruling, and now they're reinforced. But for citizens in New York, California, and Maryland, this is a lifeline, a door finally opening after decades of being locked. You no longer need to prove danger to earn your rights. Meeting the basic legal requirements, background check, training, age, is enough. But make no mistake, the fight isn't over. Anti-gun lawmakers are finding new ways to stall your rights. By creating endless paperwork, by raising permit fees, by demanding character references. If they can't ban your rights, they'll try to price them out. This ruling gives you ground to stand on, but you still have to defend it. Stay informed, stay alert, and never assume the system will protect you until you hold it accountable. Chapter 5. The chain reaction. The Bruen decision wasn't the end. It was the ignition point, because every gun law in America is now under review. Assault weapon bans, magazine capacity limits, waiting periods, mandatory storage requirements. They're all being tested against the new text, history, and tradition framework. In California, a federal court recently declared the state's 10-round magazine law unconstitutional. In Oregon and Illinois, new bans are already hanging by a thread. In New Jersey and New York, judges are questioning the legality of sensitive place laws. Each ruling, each appeal, another domino falls. What started with one case in New York is spreading from coast to coast. A constitutional reckoning that's exposing how deeply some states have buried the Second Amendment. And for gun owners everywhere, it's proof that history and persistence are on your side.
Chapter 6. Freedom Reborn. This ruling didn't grant a new right. It revived one that's been under siege for generations. It told the nation, freedom doesn't ask permission. Rights don't expire. And the Constitution doesn't bend for comfort. It told every judge, stop interpreting, start honoring. It told every politician, you don't manage freedom, you protect it. The system tried to bury this right under fear and paperwork, but the Supreme Court dug it back up, dusted it off, and handed it to the American people once again. This is bigger than one case. It's the beginning of a new chapter in constitutional law, one written not by bureaucrats, but by history itself. So stay informed, stay responsible, and stay in the fight. Because when you understand your rights, you're not just defending yourself, you're defending the Constitution. This is Firearms Rights Advisor. No spin, no politics, just the truth. Hit that like button, share this with every gun owner you know, and subscribe so you never miss the updates that shape your freedom.